to fill this vacuum in national law and practice, right? And that's emerged, that development of schemes has emerged in a context where there's debate about voluntary standards versus pushing for more legislation and implementation of legislation at the national level. But the logic of those who initiated this work in the schemes is that those schemes are a means to promote that change, right? To get us to a point where national law will hopefully be aligned with international standards, and also to ensure that local assertions of rights are recognized and respected. Um, and Indigenous people played an important role in that across all the range of schemes that we're going to talk about to varying degrees in terms of getting standards that relate to certification to reflect their rights. Um, Businesses have increasingly started to rely on these certification schemes as a way to demonstrate the sustainability of their products and that their supply chains are rights compliant. Um, but over the last years, there's been a lot of analysis of the effectiveness of this, and what that tends to show is that there are often cases where the auditing and verification of the standards is not sufficient to actually guarantee that there's compliance with those international standards. And in addition, as Robbie mentioned, there's gaps around participation in governance structures and the effectiveness of grievance mechanisms. Um, and today, in today's context, we have a sort of a trend away from regulation. States kind of moving back from that in the current geopolitical context. Um, And that's leading to an increased focus on certification again, sometimes through legislation that's saying that getting you certified is equivalent to doing human rights and environmental due diligence. So that again puts increased emphasis on the need to ensure that certification schemes are raising the bar, as was their initial intent, and are not just sort of rubber stamping or obscuring violations of human rights and environmental harms for end consumers. Um, and we're also in a context where new standards are being developed that are weaker than what we have in these certification schemes, particularly in the mining sector. And so there's quite a complex kind of landscape. So within all that, we decided that it would be helpful to develop a background paper that looked at six main schemes that are very common in Indigenous lands. So the Roundtable on Sustainable Palm Oil, Forest Stewardship Council, Initiative for Responsible Mining Assurance, and the Aluminium Stewardship Initiative. So that's in the palm oil, the forestry, wood and paper-based commodities, the mining sector, and specifically the aluminium sector, and then also look at two schemes, Architecture for Red Plus Transactions and Vera, that are in the carbon credit and that kind of emerging nature market sector. And the goal of this, the goal of the paper, and more broadly of of the convening, was to basically ensure a common understanding and awareness of the diversity of these schemes among Indigenous peoples, because as I said, many are familiar maybe with one or two and have a lot of experience, but not at a structural level across all of the different schemes and what their commonalities are, so that we all had a shared understanding of what the strengths of these schemes are, but also their weaknesses, what the opportunities are, and what the risks associated with them are. And then based on that, to sort of take stock together and compare the experiences different people have, and to come up with strategies for improving these schemes and standards. So for each standard, the background paper goes through and looks at the components of the standard in terms of Indigenous rights, looks at issues that have been identified, particularly in relation to auditing and verification, and recommendations that are already being made. So prior to the convening, there's a lot, as I said, there's a lot of documentation, there's a lot of work being done on this. So it's kind of consolidating all of that to have it as a basis for a discussion and an exchange. And some of the kind of key findings that come out of that pre-existing documentation, I'll just summarize very briefly because we'll get into more detail from the participants and what came out in the actual convening itself. But a very clear kind of focus of all that documentation is that the reality is there's a lack of legal recognition of Indigenous peoples' rights, as we all know, in most countries. But that places an increased responsibility on auditors not to rely on national law, which unfortunately has been a tendency in some contexts, and instead to look at the gaps between national law and international law that the schemes were ultimately designed to uphold. A number of challenges in relation to audits of in relation to Indigenous rights are kind of identified in those publications and literature. One around the knowledge of Indigenous people's rights by auditors, so their actual exposure to that, and the fact that in many cases the auditors aren't in fact equipped to actually assess the impacts on those rights because they don't have that, and assess ethic process because they don't have that knowledge. And that's very much compounded by the fact that timeframes to do audits are very constrained. So entering into a community to understand their situation, often very complex contexts, the time that's available is often insufficient to that for that. And then a big sort of concern, a structural concern across all of the schemes, which came up in again a lot of the documentation, is the fact that auditors are paid by the companies, hired by the companies, and this potentially compromises independence and can create conflicts of interest, at the very least, perceptions of conflicts of interest among those who are being asked to participate in the audit process in the communities. The schemes themselves, they range in terms of the level of detail, and some are very comprehensive, others less so. But when you get into the detail of the standards, even in the good standards, there's still scope for improvement, and there are revision processes aimed at trying to do that. But greater clarity for auditors around things like identification of customary lands, around how ethic should be sought and ethic protocols should be respected, and links between free prior informed consent and impact assessments. One issue that was quite prominent was cases where ethic free prior informed consent was not obtained in the past, and what that should mean for projects today, what needs to be done in order to remedy that to a satisfactory level for the communities. And then ensuring gender impacts are specifically addressed, human rights defenders are adequately addressed, benefit sharing agreements are assessed. These are all things that will be touched on later. And then finally, overarching question of governance of the schemes and ensuring that Indigenous peoples, if they want to, have the opportunity to participate in a meaningful way with an effective say in decision making, and that grievance mechanisms, which have been seen sometimes as slow and ineffective, are aligned with the UN guiding principles, and that there are actual consequences for companies in relation to failure to comply with them. So that's the background paper has sort of in a nutshell. I'll pass back to Rabu. Thanks.
Thank you, Kahan. We'll be sharing the full text of the background paper in the chat box. So we have next Dr. Pichumanyo Pantong, who also joined us in the global convening, and she will be sharing her key reflections, takeaways from that convening. Dr. Pichuman, Dr. Pichuman is the current chairperson and the Asia Pacific member of the UN Working Group on Business and Human Rights. She's also head of research and associate professor at the Center for Future Defense and National Security at Deakin University. I'll again be putting her full profile in the chat box. And over to you, Pichaman.
Thank you, Roby. And hello to everyone. I must apologize. My voice has been affected by laryngitis, and I'm still recovering from it. So I'm going to sound like this for the entirety of my remarks. If at any point you can't hear me clearly, or if you'd like me to repeat something, please don't hesitate to indicate so in the chat box. Because I'm joining you from Canberra, Australia, I would like to begin by acknowledging the Ngunnawal people as the traditional custodians of the lands on which I speak. and pay my respects to Ngunnawal elders, past, present, and emerging, and thank them for their continuing care of country and community. Thank you so much to the organizers for putting this webinar together. And on behalf of the United Nations Working Group on Business and Human Rights, I'm very pleased to be delivering these remarks on the importance of certification, verification, auditing systems upholding the rights of Indigenous peoples. The working group, of which I serve as a chair and member from Asia Pacific states, is comprised of 5 independent experts representing different regions of the world. As part of a fact-finding and monitoring mechanism of the UN Human Rights Council, we hold the mandate from states to promote, disseminate, and implement the UN Guiding Principles on Business and Human Rights. Unanimously endorsed back in 2011 by the Human Rights Council, these guiding principles set out the duty of states to protect human rights, the responsibility of all businesses to respect human rights, and the need to ensure access to effective remedies for when harm occurs. For over a decade now, the working group has been developing a variety of guidances on how the guiding principles can be implemented by states and by businesses across various sectors. This includes thematic reports that we've done for the UN Human Rights Council and General Assembly, as well as country visit reports and information notes, amongst other knowledge products. But one topic that we are yet to produce specific guidance on is how the guiding principles apply to certification, verification, and audit systems. And the important point here, of course, is that they do apply. In other words, certification, verification, and audit systems also need to be held against the guiding principles, in particular, Pillar 2. Considering the complaints and allegations of human rights abuses that the working group has received in relation to these systems, I'm pleased that this event, along with the global convening organized last month in Indonesia, marks our commitment to looking even more closely at this topic and to working with all stakeholders, particularly Indigenous peoples, to enhance understanding of how certification, verification, and audit systems can uphold the rights of Indigenous peoples everywhere. So I'll now share my reflections that are in part informed by the global convening in Indonesia, as well as the report that's been developed. And from there, I'd like to focus on 4 key points. The first is that these certification, verification, audit systems must be more than just checkboxes on a compliance form. A recurring concern heard at the global convening from Indigenous representatives whose communities have been affected by certified projects in the forest sector, for instance, is the tendency for these systems to focus on the project's technical compliance and not enough on conducting human rights due diligence, which is central to the UN guiding principles. It was also noted that this issue stems in large part from the fact that certification schemes often lack Indigenous peoples' involvement in governance, monitoring, and enforcement. Indeed, it's important to emphasize here that while these processes can complement human rights due diligence, they should not substitute proper human rights due diligence as conducted by businesses that's meant to be ongoing, that should cover actual and potential human rights impacts that a business may cause or contribute to, and where all necessary and reasonable precautions should be taken to prevent human rights harm. Businesses using certification, verification, or audit services should therefore ensure that they are also assessing the quality, reliability, and scope of these systems, and that they are not simply trying to outsource their human rights responsibilities. The second point is that these systems need to establish effective operational level grievance mechanisms in order to generate outcomes that respect Indigenous peoples' rights through ensuring access to remedies by affected peoples and communities. It goes without saying again that certification, verification, and audit bodies are not a substitute for grievance mechanisms. Indeed, if a certification or verification or audit fails to detect harm, affected communities must still have access to effective remedies, including through judicial and non-judicial means. Or if a scheme were to claim to be addressing human rights impacts, then it also needs to incorporate its own grievance mechanisms that are legitimate, accessible, and effective in alignment with the effectiveness criteria outlined in Principle 31 of the Guiding Principles. To the third point, a certification label that comes at the expense of the very people it should be safeguarding is not certifying sustainability, but is instead perpetuating injustice. Certification, verification, and audit systems must recognize that respecting Indigenous rights is not an optional add-on, but is in fact foundational to their work. Outcomes from the global convening made it abundantly clear that in addition to Indigenous peoples' rights, free, prior, and informed consent, or FPIC, and Indigenous knowledge must be at the core of any certification, verification, and auditing process for projects that have potential or actual adverse human rights impacts on Indigenous communities. Central to this are transparent and independent verification and auditing processes that allow for Indigenous participation and which can confirm whether community rights and agreements are being upheld in practice and not just on paper. Finally, and related to that previous point, verifiers and auditors should not just be trained in industry standards, but also in human rights, as well as in Indigenous cultures and traditions. Indeed, opportunities should also be made available for Indigenous peoples themselves to be verifiers and auditors, leading assessments of whether their rights are being respected. Because for too long, Indigenous communities have been systematically excluded from decisions made about their lands and territories, resources, and futures. In contravention of the UN Declaration on the Rights of Indigenous Peoples and the guiding principles, we continue to witness business-related abuses of Indigenous peoples' rights, in particular their right to FPIC, often in areas where businesses are claiming to operate sustainably. This must end, and certification, verification, and audit systems are positioned to champion this change and drive the creation of schemes that respect Indigenous peoples as equal partners. At the same time, resourcing and support is still needed to enable knowledge transfers and strengthen Indigenous peoples' capacity to engage with these schemes as well as develop their leadership in this space. Certifications need to stand for more than just good intentions. By embedding Indigenous peoples' rights into these systems, certification, verification, and auditing processes can contribute to advancing the implementation of the guiding principles and, crucially, to ensuring that Indigenous peoples are treated not as stakeholders on the sidelines, but as rights holders at the center. So thank you very much again, and I very much look forward to seeing this work continue to develop and to see the positive outcomes that can be generated in order to enhance corporate human rights responsibility and Indigenous peoples' rights. With that, I'll hand it back over to you, Roby, and thank you again to everyone who's joined the call today.
Thank you. Thank you, Pitchaman, and we look forward to continuing the collaboration with the UN Working Group on this thematic area as well as in other matters. Now, Pitchaman will be leaving soon. Are there any burning questions for her? You can either raise your hand or type in the chat box. Raymond, go ahead.
Thank you. I appreciated the presentation. I think this is an issue that we work on nationally here in Canada. But, you know, one of the questions I'd had in part of the work and looking at it from a compliance standpoint is that in the regulatory language, you would call a lot of this work beyond compliance because there are not national standards that require people to follow or to have auditing or certification on any of this work. And so I'm curious how you would deal with these questions when national governments would frame them as a beyond compliance type of issue. Thank you.
Thank you, Raymond. Pitchaman?
I mean, intrigued by what you say, and I acknowledge that there is a lot of discrepancy and unevenness when it comes to national legislation that would mandate business and human rights, or basically the business responsibility to respect human rights. I suppose I would look at the issue more from the guiding principles perspective, right? Where yes, it's a voluntary standard, that is, the guiding principles themselves are voluntary, but we are seeing how the principles themselves are being translated into national legislation in different parts of the world. We're seeing this a lot in Europe, for instance. and where we would primarily talk more about human rights due diligence. And as I mentioned in my remarks, to see auditing as being potentially part of human rights due diligence, but not as a substitute for it. And certainly, with respect to human rights due diligence as a process, as a requirement for businesses to discharge their responsibility to respect human rights, this is not a beyond compliance issue. And I would argue that even the Canadian government has acknowledged that to an extent. In that, when we think about environmental, social, and governance issues, this is no longer just something that should be done as an add-on. It's very much part and parcel of how a business ought to be operating in order to take into account not just the risks that its operations face, but equally the risks to human rights that their operations can pose. So I think that's where we're clearly, I think, witnessing a bit of well, not a bit, a discrepancy really between the language that has emerged in the business and human rights space and the language perhaps that is continuing to be used in the auditing space. And that's where we will need to try and find intersections between the two because, as I mentioned earlier, these auditing systems, also are subject to the guiding principles. They too have a responsibility to respect human rights. And for them, in doing so, this is again not a beyond compliance issue. It's very much what they need to be doing, especially in view of the range of legislative and regulatory developments in various parts of the world. So I'm not sure I've completely answered your question there, but I do acknowledge it's a really interesting and important one, and I hope that other colleagues who will be speaking later will be able to do even more justice to your question.
Yes, so we'll
Thank
park
you.
that. Yes, Raymond, we will still have other speakers and may also be responding to your question. I'll take the last question from Kayla. Kindly introduce yourself and your question.
Great, thanks. My name is Kayla Marie Earl. I'm from Canada. I work with Ray Cardinal on regulatory mechanisms to improve free and prior informed consent and implement the UN Declaration in energy regulation. The question I had was just understanding where this auditing should be administered from. It sounds like you're thinking about like compliance and auditing measures directly from proponents, so the people who are doing the business. Ray and I work in energy in particular, and I think like from a Canada perspective, a lot of these businesses have made significant strides in working with Indigenous people, but it didn't stem from them voluntarily doing it necessary, but rather that there was extreme armed conflict in our country because Indigenous rights weren't being honored. And so that ended up resulting in the breakdown of national regulatory like groups. And then they had to rebuild after all of the conflict, realizing that they had to respect our rights in order to be successful at projects. So it wasn't from, I think, companies or proponent perspectives doing all of this sort of work. But I did notice in Canada that when it came to auditing and compliance, that the most successful mechanisms were either something like what Ray has done, where it's like this like third party working without prejudice to observe the work and then tell the First Nations what's happening, and then they can be empowered to provide free and prior informed consent. Or the First Nations actually working with those types, and or First Nations working with those types of mechanisms to build their own like internal legislation and laws. So like heritage policies, for example, to protect sites of cultural significance. And so I'm just curious about what kind of successes you and others have seen uh, on something like administration and auditing.
Thank you. Thank you, Kayla. Just a reminder to everyone, if you're not speaking, kindly mute your microphones. Pichomon, would you want to give a brief response to that? Because I know the next speakers will also be touching on that, on the question that was raised.
I'll be honest, and I didn't catch the very final set of words that you had said because of the audio interference just now. What was the, would you be able to help summarize the question? It was about positive examples, was it?
Yes.
Where,
Uh, uh, because she was asking where this is leading to, because in the case of Canada, it was more stemming from the indigenous peoples coming out with their own practice, no? But in the global convening, what we did was more analyzing from our experience from the business proponents doing certification schemes. But of course, it's also coming out from the recommendation scale that there's a need for us to push for our own systems, indigenous-led audits, indigenous-led assessments, within these certification systems. No, but I'll give it to you, Pichaman, to respond, and it will be touched on also by the other
sure,
speakers.
sure. Excuse me. In view of how this will be in touch by the other speakers after this, I will leave it to them to better respond to your question there, Kayla. But I think the points that you've raised are important ones, demonstrating the agency and the important contributions that Indigenous peoples are making and stand to make when given the opportunity, the space that they rightfully deserve to have in these conversations and decision-making spaces. I would also just underscore again that I'm aware we're here to talk very much about these auditing processes and systems. At the same time, in view of how the UN guiding principles and on business and human rights apply, I would also encourage us not to see these auditing processes as sufficient, because really in many cases they are not. It's very important again that businesses continue to observe their responsibility to respect human rights in line with the guiding principles by conducting human rights due diligence. And this is something that's explained and set out in the guiding principles themselves, as well as in a variety of documents and guidances that the working group has produced. But this is where I would say, again, that human rights due diligence is not something that can be replaced by auditing. And at the same time, the certification, verification, and audit systems also need to be subject to the guiding principles, and they too need to conduct their own human rights due diligence to see how their processes can potentially or in fact have an adverse impact on human rights. So I think I'll just leave it there and hand it back over to you, Roby. I must apologize that I have to leave early because I have a fever and a range of other things. But I look forward to seeing this recording afterwards and listening to everyone's thoughts then.
Thank you, Pichaman, and get well soon. Ray and Kayla would also be interested to know more about the work that you're doing. If maybe you could share some links in the chat box, we'll be happy to look at that. Um, Thank you, Pichaman. Now we're going to the next speakers in our agenda who will be sharing the findings and key experiences of Indigenous peoples in different certification and audit schemes. We have um, we have with us John Brownman. John Mimley Brownman is a Liberian with over 20 years of experience in community-led development and works for Green Advocates International in Liberia, West Africa, a nonprofit environmental and human rights organization. We also have Norman Jiwan, who is an indigenous Kerambay Dayak from West Kalimantan, Indonesia. He is a long-term social justice advocate with deep experience in the palm oil sector. Um, and he has extensive experience engaging with the roundtable on sustainable palm oil. And last, we have Nicolas Peters, who is a policy and advocacy coordinator at the Amerindian Peoples Association, a non-governmental organization that advocates for the cultural, social, economic, environmental, and human rights development of indigenous peoples in Guyana. I'll be sharing their full profile in the chat box. But first, we'll start with colleagues. Can you kindly share the PowerPoint presentation? And we'll start with the sharing first from John, and then we go to Nicholas, and then Norman. John, go ahead.
So much. It's a pleasure to be here and seeing some of you again. We would like to talk on the experiences of indigenous people on the certification scheme and a related audit system. The first issue we would like to discuss would be some of the foundational systemic issues. Well, there has been a lot of change in the languages on this documentation by many of these certification schemes. However, these schemes fail to recognize or respect indigenous people rights as enshrined in UNDRIP. Also, these communities are displaced in the process of land grab. Community members are criminalized when they try to do advocacy for the land, and indigenous knowledge is eroded because of the issue of land grab under the pretense of development. Indigenous people treated without their own self-determination, and they are also used as tools rather than the fact that they have the foundational knowledge for whatever development that they need. We have a situation where you have extractive industries legitimizing under the guidance, legitimizing extractive industries under the pretext of sustainability. We definitely reward compliance over care. They go speed over integrity and honesty, and there is market legibility over relational accountability. Next slide, please. Next slide, please. The certification scheme and associated auditing system. We have a situation where the existing certification scheme and the auditing system are perpetuated pre-existing and ongoing violation of indigenous people rights, putting a stamp on sustainability of the product that is derived without FPIC. That serves as a legitimate ground for irresponsible business conduct. In some cases, the certification has even put more indigenous people at risk by opening up increasing demand for their commodity resources and leading members of the indigenous community to be imprisoned, driven out of their land, and lack of their traditional livelihood because they try to defend their rights. Now, many certification schemes call for green transit that are calling for green transition However, they use that as a pretext for profit making. They amplify and extract more resources because they know that eventually everybody is calling for green transition. However, that is a blind spot that they are trying to use in order to make more profit, all because everybody is trying to go green. Now, one of the major issues that affect traditional or indigenous people are the grievance mechanism. The grievance mechanism are usually complex for indigenous people. They are very inaccessible, they are costly and ineffective. While the investigations are rarely independent, they are conducted by actors or auditors who are linked to the certification scheme. And as an indigenous person, this is one of my major focus for which I will make some recommendation for the change to this grievance mechanism or the audit process and these standards. We want to ensure that one, there should be effective remedy for victims of communities by getting the companies to implement the complaint panel decision within a regional time frame. We have an experience where from 2012 to 2025, our grievance mechanism in Liberia against an Indonesian oil palm company has not been concluded because there's no reasonable time frame. Secondly, we should introduce measures to prevent divestment of some of these companies outside of the community consent. Companies having violated community customary laws and indigenous people rights, having known that there will be some backlash, will easily divest without communities getting to know about it, and that should be put to a halt. Thirdly, we want such that to recommend that we identify and enforce appropriate penalties for lack of compliance with complaint panel decisions. Because of the non-binding nature of some of these auditing schemes or systems, people can decide to divest or withdraw, for example, from the RSPO and other auditing system because they are not strong binding.
I think John, um,
Other
let's see.
stakeholders to be able to publicize and enforce policies on protection of human rights, whistleblowers, complainants, as well as community members. We can see that due to the lack of the enforcement, uh, consequences for violating these instruments, nothing is done, and these harmful properties or practices continue to violate the rights of indigenous people without any support, even from central government. And so these schemes are actually bulldog without teeth. There's only noise they make, but compliance and enforcement is very weak. Next slide, please.
Uh,
Next,
John,
we look at the
this will be,
auditors and
yes, this will be with the next speakers, Nicholas and Norman. But um, if you have anything to add on the experience of Liberia in relation to palm oil, you've already given important recommendations in relation to remedy mechanisms and also compliance of companies, even if it's a voluntary standard. But adding to that also is our recommendation for state legislation in relation to the recognition and protection, fulfillment of Indigenous peoples' rights in line with the UN DREAP. Do you have additional sharing in relation to the case of Liberia?
Well, in our case in Liberia, under the RSPO, uh, the company decided to withdraw. Golden Verulam Liberia decided to withdraw from the RSPO at the time. However, the decision backfired and they were constrained to come back to the RSPO because their parent company in Indonesia refused to withdraw from the RSPO. Um, the complaint panel decision against the company made the company to initially engage the communities. However, due to the lack of strong enforcement policies, that that is still process is still ongoing. Indigenous people continue to suffer from the human rights violation, pollution, and forceful displacement of the land. And so, from our perspective, these compliance mechanisms are good. They bring the companies to the table, but they are not strong enough to keep the companies negotiating. And in most cases, auditors that is
I think John's internet connection is unstable, but we were able to get his message in relation to their experience on the palm oil commodity. And I think Norman will also be sharing the same experience from Indonesia. So we now go to Nicholas to be,
pay or to the
uh, sorry, John. Okay, Nicholas, over to you.
Thank you, Ruby. Thank you, everyone, for joining, and thank you for the invitation to participate in this webinar. So, as Ruby introduced, my name is Nicholas Peters, and I work with the Amerindian Peoples Association in Guyana, and we are an Indigenous rights NGO in Guyana that works very closely with our communities, with community partners and um, international partners throughout the world. And in our case, I'll be talking about our experiences under the emerging carbon markets programs that are coming out of a response to the climate change crisis that's ongoing. And in our experience, we've been working very closely with the architecture for REDD Plus transactions, and this is the art body known as a verification body, a verification validation body within this carbon market scheme. And so from just a bit of context in Guyana. So Guyana is in South America and it has about a 85% forest cover. This forest is from the Amazon, as part of the Amazon basin. And so as our country develops and moves in the direction of a more sustainable development goal in the environment, the government has taken the approach of utilizing our forests to gain access to financing to maintain the sustainable livelihoods of Indigenous peoples and to steer the direction of the national development that's happening currently. And so within Guyana, we've adopted a jurisdictional REDD Plus initiative. And this is where we've gotten our financing for our carbon wealth, you can say, because of the role that Indigenous peoples have played in the sustainable and long-term maintenance of these forests. We have received a lot of attention. And so in 2022, the government of Guyana entered a deal with the Hess Corporation uh, to trade in the carbon markets space. And in this case, um, an agreement was an agreement was formed for about 750 million US dollars for the period from 2022 to 2032. And the Hess Corporation, which is a big oil company, is going to be paying the government of Guyana about 750 million US dollars, which would equate to about 37.5 million carbon credits. And in this sense, for these next 10 years or so, Indigenous peoples are meant to benefit as about 50% of the proceeds that come from this deal with the Hess Corporation. And in our case, you do have the fact that Hess Corporation is an oil company, and that Indigenous peoples own as about the they in our case we have legal recognition is about 14 to 16%, but Indigenous peoples legal customary territories is about 30% or more. So in our case, we've been trying to really work closely to understand this very new dynamic of commodification within the forest service area, within the environmental scheme, and to really build the knowledge and technical experiences of our community partners to understand these new systems. The issue arises from our experience in Guyana as the issue is that we have had this deal that's been pushed forward by the government and has been signed with Hess and has been certified by the ART process, the Architecture for Red Plus Transactions process. But there hasn't been sufficient free prior informed consent principles from the exercises and the consultations that we have conducted with communities. This is what we've understood. And although the government has made its claims that they've conducted consultations with communities, we found that these consultations have been lacking. They've been really missing information with regard to how carbon rights are related to now Indigenous communities' rights, their land rights, and how ownership and long-term benefit sharing within this scheme can really develop. So given that experience, we had launched a complaint we launched a complaint to the Architecture for Red Plus Transactions stating that Indigenous peoples were not fully consulted in this program. And so what that meant was that we wrote to the Art Secretariat to raise our concerns, to let them know that although the government has had endorsements from Indigenous leaders on this overall sale, it shouldn't be regarded as a complete consent by Indigenous communities in the country, because the rights to consent to resource use and Indigenous titles of their lands is still regulated to the village councils that manage territories and manage the villages that we have in Guyana. And so after we launched this complaint, it was rejected by the Art Secretariat, and therefore we sought to activate the grievance mechanism following the Art Trees standard, which is the environmental excellency standard that ART adheres to. We were unsuccessful in meeting the full appeals process because we found that the system that the Art Secretariat was working with was insufficient in terms of ensuring an independent view, an unbiased view, and a transparent view in terms of the outcomes as to how our complaint could be now taken to the next level to have some action behind it. So we decided to withdraw from the appeal process given some of the internal technicalities that we saw and some of the challenges we had in terms of just consulting with our leaders, because our leaders are from the communities. So in Guyana, we've really been advocating for more of a push for a greater consultation, greater respect for FPIC because of the new nature of this carbon market scheme and how it's connected to a global action for climate change, as well as how it is connected to Indigenous people's rights to their lands and territories, which is still a process that we are working through in Guyana and a process that we are actively involved in as the APA. So having had the experience in Indonesia with the Rights Energy Partnership and the other partners, we have come to recognize that this is part of a very systemic procedure that really deprioritizes or really minimalizes how Indigenous peoples are consulted in these processes. We all learned that many of the issues that we shared are replicated in a lot of the commodified spaces, whether it be timber, logging, mining, the palm oil industry. And so for us, we really took the position that there has to be greater consideration for FPIC and a greater compliance to FPIC in terms of how auditing bodies or verification bodies interact with Indigenous peoples. We at APA have had experiences with the auditing body under the Art Secretariat to verify that the government has followed the appropriate measures and appropriate standards. But we are still of the position that these systems need to be reformed in a way that can really take the concerns of Indigenous peoples into the overall reports and the certification processes that happen. Because although we've been raising our concerns directly to the certification bodies, to the government, there is still an approach of going ahead with these programs and going ahead with agreements without really consulting communities. And in our case, you have a situation whereby you have the agreement and then you have the exercises, the activities to ensure people understand what they're entering and to ensure that the plans that this money, this finance is going to at the village level continues. So we have a big issue with that because in our case, we still have communities who, while they recognize the benefits that finance can lend to them through this scheme, they still want more information about what it means. They want information in their language, and they also want to be able to be part of the negotiations for how this can work, especially since it seems that our communities can see the benefit from it, but would rather a fairer deal from this agreement that our government has entered with HES, and also that will be pushing forward other companies. So this is something we've been working with, and the experience in Indonesia was able to give us a sense of how we can consolidate a lot of the common issues and to have it be more directed at the certifiers, the buyers themselves, the government in our case, because this is a jurisdictional initiative, so the government is the lead on this. And so the buyers, the investors, the government, and I think the businesses who are really, and the certification bodies who are moving these projects ahead. We have participated in further auditing exercises by the Art Secretariat. But in our case, we have taken the approach to really learn some more from communities, what they would need from these type of processes, and how we can push not just directly to the certification bodies, but push for more of a unified position among communities and Indigenous representatives in Guyana, because there is a sense that that communities are okay with getting benefits from a scheme like this, but they do need more information. And when it comes to how equitable the benefit sharing is, this is still a question of how do we implement this, especially given that Indigenous peoples have an outsized role in protecting forests and maintaining the environmental benefits that the government wants to claim. There's also the question of the rights to this new scheme, the rights to carbon and the rights to other schemes that we see emerging, especially biodiversity and and Indigenous knowledge systems. These are things that we're paying attention to and things that we see having a similar and repeated effect. So having had this opportunity to work with other partners in Indonesia to really understand where we can have an entry point and where we can make some inroads in terms of applying pressure and applying the systemic reform that we want to have, and not just have, Indigenous peoples on these certification bodies be tokens, but to have them have a active role in defining these things and to have an active role in defining how auditing processes can work is a big aspect of how we see improvements to the overall system within this carbon market system, but also within other commodification schemes that are emerging and that in the case of my country are likely going to affect us along the line. So I think that is about my time. And so I'll just leave it there and open to questions when we have a discussion session.
Thank you, Nicholas. And finally, Norman.
Thank you. Very good night here from Indonesia. Again, my name is Norman Jiwan. I'm self-identify myself as Dayak indigenous people, indigenous persons. I'm based in West Kalimantan, Indonesia. My sharing will be more on experience in my at least 8 years with the RSPO Roundtable on Sustainable Palm Oil Standard Setting Processes, and then my own experience using the RSPO certification system or processes in one of the community indigenous people in West Kalimantan, where they try to use this RSPO complaint mechanism process systems. The process was actually from my point of view, the auditors of the certification body, since the filing of the complaint in 2012 until 2019, the certification body, those who have to verify a time-bound action plan by the company in a certification process, they have never managed to really understand the rights of indigenous people and the standards of RSPO, which require free, prior, and informed consent. Take, for example, if the certification system and audit process really comply and follow FPIC process, the company, the certification body and auditors must understand and follow the basic and fundamental free, prior, and informed consent that is consistent with United Nations Declaration on the Right of Indigenous People. And if land grabs or land grabbing already happened in the past, there must be a land restitutions as part of the process of remedy. But the auditors or certification body failed until the company decided to divest and sold that entity. RSPO standards and the certification system and complaint mechanism system are all failed to address these complaints under the certification audit verification processes. So that is the first issue related to lack of expertise of auditors about indigenous cultures, languages, histories, especially histories on past land grabbing. And growers or oil palm plantation company claim that they have done consent, then they have obtained consent in the past, but why they have to repeat or revisit the compliance on pre-prior and informed consent? That from our point of view, that is really problematic, because in the past decision-making processes were being manipulated or not led by indigenous leaders, but the decision-making process in the past was taken and made by military, engineered, police present, and intimidation process. That, from my point of view, from my experience using these RSPO certifications system and processes, really auditors of the certification body really were not as expert enough or don't understand our indigenous people's rights. Because if we are talking about indigenous people, we are right holders, not as stakeholders. This understanding is totally different from the RSPO certification system. And the audit procedures, from my point of view, they really frequently fail to allow sufficient time for meaningful community engagement, including with indigenous women, elders, youth, and persons with disabilities, and other vulnerable groups. In this audit process, I mean, they always came and checking whether or not the indigenous communities already agree to sign on an agreement that a process to start mediations or land dispute settlement agreement. So that is the process they try to convince the indigenous people to agree. While the facts on the ground was the conflict has never been dealt with and addressed or resolved properly. So that's from my point of view, from our experience, audit procedures not really provide an opportunity that really not only time, but also meaningful engagement to really solve and address the land grabs issues. And the last issues is the lack of independence of auditors. They are hired and paid by the entities seeking for certifications, which creates conflict of interest and disincentive flagging of violations. In my own experience, in other complaint back in 2007, we filed complaints against RSPO members company against the certification body performance because instead of auditing the company compliance against RSPO standards, these auditors and certification body, it is advising the company and defending the company failures to comply with and respect indigenous rights in land and forest and livelihoods of the communities, indigenous communities that are being impacted by the operations of these RSPO members. That's another example how, in our experience, the lack of independence of auditors are very serious issues and problems in certifications processes. And then that is based on our my own experience dealing with cases relevant with certification process and audited processes. I'm qualified auditors. I'm trained. I was trained to do audit on palm oil and sustainable forest management certification audit. I was trained in Oxford with ProForest back in 2007. But what are the bigger implications of this failure? International voluntary best practice, only best practice on paper. RSPO make it very clear, zero deforestation cutoff date back in 2005. But the standards itself have never been properly stopped deforestation in Indonesia. In 2023, Indonesian government just concluded an audit that 3.3 million hectares of oil palm plantation illegally planted in forest areas in Indonesia. So what does that mean? This means international best practice failed to stop deforestation, even when they have and put zero deforestation commitment back in 2005. And then in Indonesia, for example, it's just contribute nothing to stop deforestation from happening. That is massive. And according to that, the government audit, the findings was not really shocking from my point of view, because majority of the companies identified planting oil palm plantation illegally in forest areas, 3.3 million hectares. Majority of those companies are RSPO members. So what the certification can do to stop deforestation, because it's already in the standards. So I think because of time, I would stop there. For our experience from Indonesia and looking at the uh, future, this has to be good on paper, but also has to be good in terms of providing remedies and human rights on the ground with for indigenous peoples and other those who much need it of the standard to be working properly. Thank you very much.
Thank you, Norman. And now I go to the last part of the virtual event. The recommendations coming out from the convening. I'm giving the floor to Praveen. Pravindra Shakya is the convener of the Asian Indigenous Peoples Network on Extractive Industries and Energy, and also the founder director of SEMSOJ, Community Empowerment and Social Justice Network in Nepal. He's a human rights activist from Nepal's Indigenous Network community. Praveen, over to you.
Yeah, thank you, Roby, Josalapa, namaste, everyone, and thank you for taking time for this. Thank you for taking time out of your Friday for this webinar. Glad to have you all here as one of the co-organizers of the global convening and this webinar. As Roby has already said, and much has already been shared by the participants of the convening itself. Yeah, from the regarding the convening as well as the experiences of the indigenous peoples and the declaration that came out of the convening. No, so I'll basically be summing up some of the key recommendations that we have made to the states, businesses, certification schemes, certification bodies, as well as investors and financial institutions that were included in the declaration of the global convening. As has already been shared, the convening was organized in Jakarta in March. 32 members of indigenous peoples from 13 countries deliberated on various schemes that certify commodities for international markets, including uh, including um, including minerals and metals, palm oil, wood, pulp and paper, carbon and biodiversity credits, renewable energy, and aquaculture products. As noted in the preambular paragraphs of the declaration, and as has already been, as is already evident from our earlier speakers, these participants, many of those participants had actively engaged with various certification schemes over the past 3 decades to try to prevent adverse impacts from the schemes by putting in place strong safeguards for the rights of indigenous peoples. And again, as also as has already been noted, there have been some important gains with these certification schemes, with some of these schemes now embedding respect for our rights. However, from what we have already heard, based on the cases and experiences shared at the convening, it is abundantly clear that in an overwhelming number of cases, certification processes have not resulted in guarantee for respect of indigenous rights in practice. Two other key things in the preambular paragraphs, I think, in my opinion, are that we are concerned, the participants of the global convening, as we discussed in the global convening, we are concerned that many certification schemes, and including the new schemes emerging in response to the call for a global transition, have evolved into market and profit-driven businesses, promoting false climate solutions that commodify our lands and resources in contradiction with our own, with indigenous worldviews. And as noted in the final part of the preambular paragraph, true recognition of indigenous rights must go beyond mere participation in these market mechanisms and should respect indigenous sovereignty and land tenure security and FPIC in all decisions that impact us. No, that is why we have also clearly called on for seek models that center indigenous-led frameworks, ensuring that any process affecting our lands and livelihood is accountable to us. So based on these deliberations, so these are some of the key recommendations that we have included in the declaration. First, to states, we have called on the states to align laws with a UN Declaration on the Rights of Indigenous Peoples, to adopt and enforce necessary policies in line with the UN DRIP. Secondly, the states should also require mandatory human rights due diligence from companies so that the companies carry out due diligence beyond certification compliance, as has already been said. Like, certification should not replace due diligence of companies. Thirdly, we are also calling on states to enforce FPIC universally, free, prior, and informed consent universally, and also respect FPIC protocols of indigenous peoples where they exist. Fourth, states should provide accountability and remedies and hold businesses liable for violations, including clarifying legal responsibilities of certification schemes themselves in in human rights harms when they occur. And finally, states should support, rather than external projects, indigenous people's own solutions, indigenous people's led solutions, by recognizing and funding indigenous initiatives for just transition, which will also include their own impact assessments, their own energy and conservation solutions, and maybe also their own certification processes. In the second set of recommendations, these are to the businesses. We are calling on the businesses to uphold UNDRIP and FPIC in line with their responsibility under the guiding principles, the UN guiding principles on business and human rights, and particularly respect indigenous laws and protocols, FPIC protocols where they exist. The businesses should also conduct effective human rights due diligence, as has already been repeatedly said, throughout their supply chains, and require their suppliers to also be certified through independent and transparent audit processes. The businesses should act on violations and suspend or terminate relationships with their suppliers or vendors when there are credible allegations of violations or confirmed abuses. And they should ensure safe grievance mechanisms, that are accessible, that are gender responsive, and with zero tolerance for reprisals. Yeah. And businesses should support ethical certification, and not engage only in schemes, only with certification schemes that guarantee UNDRIP aligned indigenous rights in words as well as in practice. With regards to certification schemes, we have these set of recommendations, which again have been said by different actors. So I'll just quickly go through them. We have called on the certification schemes to include indigenous peoples in development and updating of the standards, to require FPIC in all audits and remedy processes, to disclose audit process reports fully and accessibly to the affected communities, and particularly for indigenous peoples in voluntary isolation, audit certification schemes should not carry out any certification for projects carried implemented in those territories, in the territories of indigenous peoples in voluntary isolation. And also for certification schemes to have indigenous representatives in their governance structure with decision-making authority. Yeah. With regards to audits, I think Norman and others have clearly said we would like the auditors to be trained on indigenous rights, and indigenous experts to be hired as auditors. And there should also be provision for unannounced audits, so that there is unannounced audits and rotation among audit teams, so that there is independence and effectiveness of the auditing processes. I'm I'm told there is very little time, so I'll try to go quickly with this. With the certification bodies, again, the recommendation is to train auditors on indigenous people's rights and human rights standards, and particularly to obtain FPIC from indigenous communities before audits. And these bodies should also conduct peer reviews with indigenous rights experts and oversight bodies. To NGOs and CSOs, because often the involvement of, or engagement of NGOs and CSOs with these certification schemes lend credibility to the schemes even when they are not doing good. So to our fellow NGOs and CSOs, we are calling on that the NGOs and CSOs should only engage with certification schemes that truly respect indigenous people's rights, again in standard as well as in practice, and they should also promote indigenous people's meaningful participation in all activities of the meaningful participation in all activities of those certification schemes. And to the UN human rights mechanisms, as already been noted by the by Pichamon, we are calling on the UN human rights mechanisms to monitor these certification schemes as well as the auditing processes in line with the UN guiding principles and other human rights standards. And when there are disputes or complaints against the certification schemes, to also facilitate mediation. No. Finally, to the investors and financial institutions that invest in the businesses that are that have operations that are being certified, we are calling on these investors to map and disclose all their investments impacting indigenous peoples. We are calling on them to we are calling them urging them to require verified FPIC to verify obtaining to verify that FPIC has been obtained for all their investments affecting indigenous peoples, and most importantly, that the investors also carry out their own human rights due diligence, not just depend on the human rights due diligence of their investees. And finally, the investors should investors and financial institutions should also conduct their own, independent verification of the certification compliance of the certification schemes compliance with international standards. And if they find non-compliance, they should take immediate action, such as suspending investments and even terminating relationships if the non-compliance are confirmed. No. You can find the declaration as well as the press statement by scanning this QR code. We have also discussed a roadmap, and this webinar is part of the our ways forward or steps ahead. But at the same time, as one of the co-organizers of the global convening, we would really appreciate if all indigenous peoples representatives attending this, as well as our allies, could lend support to this declaration, so that we can put collective pressure on these certification schemes to do better, and at the same time even think about our own certification or like indigenous led frameworks for certification schemes. Thank you, Robbie.
Thank you. Thank you for being. For We have 2 minutes, unless people are okay to extend for another 5 minutes for question and answer. Thank you, Crispy, for the comment in the chat box with regards to IRMA. We also look forward to working with IRMA auditors to strengthen capacity and knowledge in relation to Indigenous peoples' rights, but also the grievance mechanism of IRMA to strengthen its accessibility and effectiveness for affected Indigenous peoples. I now open the floor for questions or sharing from other participants. You can either raise your hand or type in the chat box. As you can see in the sharing from different speakers, now while we are involved in different commodities, there's common experience in relation to Indigenous peoples not being considered as rights holders, but just as stakeholders in many of these voluntary schemes, but also in relation to access to remedy. Even if complaints were filed, there's no timely resolution of complaints and concerns that were filed, and violations are continuing and increasing on the ground. And the other point that was also raised is the common experience among indigenous peoples on the loss of land and livelihood brought about by the projects that are being certified by these different certification schemes and audit systems. Any questions? I don't see any hand up. Kahal, go ahead.
Yeah, no, just to come back maybe to the question that was asked earlier when Pichimon was talking about this beyond compliance, and if these schemes are beyond compliance. I suppose my answer to that is that international human rights law, and in particular international human rights law, because there are mechanisms for overseeing compliance with it, although they have no enforcement power, have all made it very clear to states that these are obligations, that what the standards in, say, we take IRMA, talks about the UN Declaration on the Rights of Indigenous Peoples, as do other standards. These are obligations that states have under existing human rights treaties that are legal commitments that states have made. So there's afterwards, the states haven't transposed those obligations into their national law, but that's a deficiency on the part of states. So I think, in that context, it's really about states fulfilling their obligations, and the problem is it's a gap there, and that's why we have these standards to try to fill that gap. But then, as pointed out by Nicholas and Norman and John, in practice, sometimes even if the standards say this will happen, in practice, the interpretation or the understanding of that is not there, or the process is not adequate to make sure that happens. And that this process that we're going through now is to try to address those deficiencies and try to raise the bar across all standards, and use where there's good examples, use those to talk to standards where there are poorer examples, or where there's maybe structural issues with auditor understanding or perceptions of lack of auditor independence, that we have those conversations and see what can be done to get back to the original intent of ensuring Indigenous rights are respected. That we bring national standards up to the international level, and that we ensure, coming back again to the point from the Canadian folks who are here, that local Indigenous law and instruments that Indigenous peoples articulate, say in relation to free, prior, informed consent, or regulation of activities in their lands, or no-go areas, that all of these are respected. And that's, part of the international human rights framework that's now embedded in most of these certification standards. And how do we translate that into practice and encourage states to move in that direction as well as corporations? So yeah, that's just coming back to those earlier questions.
Thank you. Thank you for that, Kahan. And precisely also, that's the key recommendation coming from the convening as well, no? That these voluntary standards should not replace the obligation of states to um, implement Indigenous people's rights and put in the necessary legal frameworks. And they should actually complement the implementation of states. No, it should not replace. And also for businesses, that they should not be an excuse for them to not do human rights due diligence, and have still conduct that, including having necessary remedy mechanisms in place where affected communities can go to, not only in certification schemes, but also in businesses, among investors and the state level. Because as we have seen in the sharing, as we have heard from the sharing, no, just relying on the remedy mechanism of certification schemes is not enough to really provide access to justice for affected Indigenous peoples. Um, and with that, this is the first of the many events that we will be conducting virtually and in person to share the results of the convening, but also to have a dialogue and continuing collaboration with relevant bodies to be able to strengthen business business practice in respecting Indigenous people's rights. If you will be there in Bangkok for the Responsible Forum on Business and Human Rights, and in Geneva for the UN Annual Forum on Business and Human Rights, we will be conducting a session in those events in relation to this. And if there are no burning questions, we thank you so much for attending this meeting, and we look forward to continuing the engagement and discussions with you all. To our colleagues from Canada, we look forward to hearing more of your experience, as well as we continue to compile and consolidate experiences of Indigenous peoples in relation to this thematic area. Thank you. Thank you, everyone. Thank you also to the speakers, and have a good weekend.
Thank you.
Thanks,
Bye.
Rory. Thanks, everybody.
Thank you. Bye, everyone. Take care.